Hey guys, it's George Saldana with Texas Team 2503, and I want to go over the three strikes law, interference with child custody, SB 2794. It's been voted by the House and the Senate, but it hasn't passed into law just yet. Whether it gets passed or not, let's dig in. For some of y'all that have been following me, some of y'all know that my niche is interference with child custody, Texas Penal Code 2503. I wasn't given the opportunity to give any input on this bill. And I know the people that brought it to the legislature. And I can tell you, I don't think they're telling you the truth. And that's why I want to go over this bill. Whether this bill passes or not doesn't matter. It still needs to be said that there are people out there that are trying to misrepresent what this bill actually is and is going to do for our community. So I think it's important that we dig into it and we look into what this bill really is going to do. So I'm going to read you 2794, filed by Senator Angela Paxton. Sections 2503B and D Penal Code are amended to read as follow. Let me repeat that. Sections 25.03B and D subsections of the Penal Code are amended to read as follows. A parent, they want to change non-custodial to parent, which is better, but person would be optimum because, well, we'll get into that later. A parent commits an offense if, with the intent to interfere with the lawful custody of a child younger than 18 years, the parent knowingly entices or persuades the child to leave the custody of the other parent or guardian of the child. Now, this three-strike bill only covers when the child is enticed or persuaded to leave the custody of the other parent or guardian. The way I believe they're selling it is that it's going to help people that have issues when the child is taken or retained in violation of that court order, which would be subsection A. But this only amends subsection B, which is entice or persuades the child to leave the other parent or guardian. Now, under this offense, subsection A is a state jail felony. So the taking or retention in violation of a court order or judgment will stay a felony. Great. I'm glad they didn't try to touch that. The offense under subsection B, which I just spoke about, the parent knowingly entices or persuades the child to leave the custody. An offense under subsection B is a Class C misdemeanor, punishable by a fine of $500, except that the offense is a state jail felony if it is shown on the trial that the offense and the defendant has previously been convicted 2 or more times. Has previously been convicted 2 or more times of an offense under subsection or enticed or persuade the child to leave the state. Okay, so if you break that down, an offense under subsection B, so it's a felony right now. Subsection B is a felony when somebody entices or persuades the child to leave your lawful custody. With this bill, and I didn't write these words, this is just what the bill analysis says, okay? It decreases the penalty. The offense under subsection B is a Class C misdemeanor, punishable by a fine of $500. So many people think that with this bill, it is going to help them when the other parent takes or retains the child in violation of a court order. Some people believe that, hey, my baby mama is going to keep the child from me 3 times and then automatically it'll become a felony. And that's not true. The way the bill reads is that an offense under this subsection B is a Class C misdemeanor. So they're decreasing the penalty from a felony to a misdemeanor when that parent says, hey, leave your dad's house, go out the back door, and I'll pick you up by the stop sign. And it has to be a parent. It can't be anybody else. It can't be a brother-in-law, a sister-in-law, a grandparent, or a sibling. That's why I suggested that maybe it should say person. When the person knowingly entices or persuades the child to leave the custody, I believe that's more fitting and it aligns with the rest of the law. Again, I wasn't able to give any input. We testified on these bills. I testified kind of neutral with the whole thing. I love when we talk about interference with child custody, but honestly, this is really a bad bill. We are watering down the felony to a class C misdemeanor twice if the parent entices or persuades the child. In my own perspective, you can't really entice or persuade the child to leave if you're having problems obtaining your child, if the child is taken or retained. But we know that law enforcement, they're not enforcing subsection A or B. So while this three strike bill looks great on the outside, it's really not. You need to actually read the bill. And I'll put the bill in the comments for you to read. Again, this hasn't passed. It's not going to the governor's desk yet. We still have a few days left in our legislative session. This could surprise us at the very end, but we shouldn't look forward to this bill. As an advocate, you really don't want to shit on other advocates, but at the same time, I think it's the advocate's duty who brought this bill to actually inform the public correctly on what this bill truly does. Misrepresenting it to the public that they are going to find relief after the third strike is absolutely incorrect. This says the offense under subsection B is a class C misdemeanor punishable by a fine of $500. Has previously been convicted 2 or more times. Not only does this kind of decrease the penalty, but you have to be convicted twice. Like you have to be convicted twice. You can't just bring this issue up twice. You have to be convicted, which means you have to go through the whole process from start to finish. Be convicted, count one. Be convicted, count two. On the third try, hey, we'll do it a felony. Now, if a parent is knowingly enticing or persuading the child to leave your custody, why should it take 3 strikes, 2 misdemeanors to make it a felony when you shouldn't even be enticing or persuading the child to leave? Again, there's parents coming up to me asking me how this bill is going to help them. And I unfortunately have to tell them the bad news that it probably won't. I believe the authors should come out and tell people exactly what this bill is going to do. They had lawyers there supporting this and talking about interference with child custody. While that's a great thing, we should all be talking about it. Decreasing the penalty in order just to get a bill signed just doesn't align with my perspective. And that's just my point of view. It's my 2 cents. Take it how you want. But you should definitely ask questions from the author. I'll help you with whatever I can. Thanks for watching, and I hope I was able to bring some clarity to what SB 2794 and the 3-strike interference with child custody bill is going to do to this community. Thanks for watching. If you have any more comments, feel free to drop them in the comments below, and I'll try to address them as I can. Later.